Judicial activism. Now let us understand. First, I'll give you a brief about what exactly the activism means, what is happening. Then we will understand the meaning of the judicial activism. Then the subsequent things, that how it started, or what is the idea of the judicial activism, why the judicial activism is growing in India, and what are the use cases. So recently, if you look into the current newspaper, you'll find out that the Supreme Court of India is being criticized. Supreme Court is being criticized for overstepping into the domain of legislative and executive. Recently, we have observed this particular narrative in many of, I would say, newspaper, that whenever the Supreme Court of India takes a certain degree of action, any form of action, and if the executive members or if the legislative members, if they feel that somehow the Supreme Court is hijacking their role, okay. Now, that is the concept itself, activism. I mean, any kind of activism, it's not only the judiciary. You might have heard about environmental activists or, agricultural activists, okay, animal activists, climate change activists. So activists are basically, they act like a pressure group. They act like a pressure group to put pressure on the government. But here, the judicial activism, it has basically two objectives. Okay. Because the judiciary is legitimate, because the judiciary has the power, so it not only requests the government, it directly takes action. Please try to understand. If I compare an example of environmental activists versus judicial activists, as far as the environmental activists are concerned, they don't have power. They don't have legitimacy. What power they do have? Only they can protest. They can stop the work. That is a kind of protest they can do. But they cannot change, um, they cannot take actions from themselves. Let's say some constructions are going on, and if the environmental activists think that it is basically detrimental for the environment, they will do the protest and they will stop the work. So they have this kind of a nature. But so far as the judiciary is concerned, judiciary itself is having the power. So judiciary doesn't wait for the government to basically take the action. Judiciary takes action by itself. Number one. Number two reason, when the judiciary itself takes action, on the other hand, the pinch is felt by the government also, because somehow it is completely visible to the public that the action what it was expected out of the executive, it was not done by the government. That is the reason why judiciary is performing. All right. So why this judicial activism is growing in case of the India? You know that there is a rapid corruption also. If you look into corruption, word itself was more popular in at least before 2014. So because of the rapid corruption, sometimes you might have seen that SC is directing, Supreme Court is directing the CBI or the other investigation agency or the police, other investigation agencies, and they are mocking the CBI and the other central investigation agencies to perform the duty. Okay, because they are not performing, that is the reason Supreme Court has to intervene. So that means sometimes what happens, though the judicial activism, it is criticized by the politician, but it is welcomed, or it is also welcomed by, you can say, advocates, they welcome this steps. You can also see it is welcomed by the public, because public को पता है कि that ultimately if I am not going to get justice from the executive or the legislature, finally कोई तो है जिसके ऊपर मैं भरोसा कर सकता हूँ, right? So that is the genesis on which the judicial activism is standing up, and we will understand more about it related to this judicial activism. Okay. So by far, in a simplistic way, if we look into what is judicial activism, we can simply say that judicial activism, it is when that judiciary is overwilling. Judiciary is overwilling to jump into the domain of executive and legislative function. Okay. So in a simplistic way, we can simply say that judicial activism is nothing but it is the judiciary is over willing to jump into the domain of executive and legislative functions. ये हो गया आपका judicial activism. Going forward, according to Justice Krishna Iyer, okay, you can quote also what Justice Krishna Iyer has said, that every judge is an activist, either on forward gear or on the reverse. So these are important quote. You can give these examples while you can give these examples while writing your answer as far as the PSR answer writing is concerned. If this
Sir,
question,
last what
which one?
i-
Form
either on forward ear or on the
reverse or on the
okay.
reverse. This is said by Justice Krishna Iyer. So remember what Krishna Iyer is saying, that every judge is an activist. Every judge is an activist, either in the forward gear or on the reverse. Now, interestingly, what is happening? I mean, sometimes we have a misconception that the judicial policy का मतलब क्या है? Judicial, when the judiciary makes certain rules, regulations in regards to the public sphere, sometimes what happens, we are having this misconception that every judicial policies are not in favor of the government. Okay, I mean, the idea is basically the judiciary is making the policy because the executive failed to do so. That is not the case. There are many occasions where we have observed the judicial policies, it can be either in favor of legislative and executive policy or opposite to it. दोनों हो सकती है. Okay. So what is the judicial activism? You can simply, another definition you can write about judicial activism, that judicial activism Okay, the judicial, this is another definition. Judicial activism, अब ऐसा भी define कर सकते हो that this is a policy. Judicial activism is nothing but policy made by judiciary, made by judiciary in competition with the policy making by legislature and executive. You can also write, you can define this, what is judicial activism, in this way. So initially we have understood that there are multiple definitions. एक चीज हम लोग क्या पढ़े हैं यहाँ पे, that when the judiciary is overwilling to jump into the domain of the executive legislature, इसको भी आप बोल सकते हो judicial activism. इसको भी आप बोल सकते हो when the judicial activism itself is a policy and which is in competition with the policy making by the legislature and executive. Okay, and पहले तो आपके मन में ये डाउट होगा दैट सर इतना तो हमें समझ में आ गया दैट व्हेन जुडिशियरी मेक्स सर्टेन पॉलिसीज, बट सर इसको एक्टिविज्म क्यों बोलते हैं, व्हाई इट इज कॉल्ड एज एन एक्टिविज्म? ओके, सी मैंने आपको पहले ही बताया था कि कभी भी अगर आपको लगता है कि इज्म है, ISM, इज्म का मतलब होता है पॉलिटिकल फिलोसॉफी, ए सिंपल फिलोसॉफी, बिकॉज वी आर इन अ पॉलिटिकल साइंस सब्जेक्ट, सो इट्स अ पॉलिटिकल फिलोसॉफी, इट्स अ थ्योरी. एंड इज्म हम तभी यूज करते हैं व्हेन इट इज यूनिवर्सल एप्लीकेबल, राइट? सो इसको एक्टिविज्म क्यों बोल रहे हैं? व्हाई नॉट इट टू कॉल इट इज अ जुडिशियल पॉलिसी? सिंपल, व्हाई टू कॉल इट इज अ जुडिशियल एक्टिविज्म? देखो, व्हेन दिस पॉलिसी इटसेल्फ, व्हेन दिस पॉलिसी causes social change or articulates, ध्यान से सुनना, okay, when the policy itself causes social change or articulates concepts such as liberty, equality or justice, तब आप बोलते हो that it is activism. Okay, understand the meaning of activism किसको बोलते हैं? When there is some impact in the life of the people. Okay, तो अगर आप एक इंसान का लाइफ के बारे में सोचते हैं, then there are multifaceted life. उसमें social changes हो सकती है, there could be economical changes, there could be political changes. So यहाँ पे the activism does not mean related to the economical changes. So whenever judiciary makes any judgment or whenever judiciary creates certain policies, and अगर वो policy it impacts the people's life and it causes certain social changes, or which also includes that liberty, equality and justice के ऊपर अगर वो वाला policy जो भी activism या फिर judgment, whatever judgment it has given, if it is impacting to these sectors, then you say that it is activism or judicial activism. ये समझ में आया? All of you are clear that why we call it as a activism and not policy? What is that activism mean by? All of you are clear? Just let me know quickly.
Yes, sir.
Yes, sir.
Okay. So you can write down these points also in your examination. So that means you can simply say the judicial activism, they make socio-economical changes. Okay. सोशियो इकोनॉमिकल चेंजेस, ये भी आप लिख सकते हैं. Now, according to Freight Becher, according to, let me just write down here. Freight Becher, okay, he says that judiciary activism, देखो वो क्या बोल रहे हैं, judicial activism is nothing but government by judiciary, government by judiciary. So he is using the term, he is saying that it's nothing but the government by judiciary. That means judiciary themselves have created a government. Okay, and he also says that another, he goes on further saying that the judicial activism, it is now, in a sense democracy's non-democratical alternative. ये और एक डेफिनेशन है, इसको भी आप लिख सकते हो एग्जाम में, अल्टरनेटिव टू व्हाट, टू रिप्रेजेंटेटिव गवर्नमेंट. देखो व्हाट एग्जैक्टली फ्रेंड, FREN, friend Becher is saying that judicial activism is government by judiciary, correct? And it is also saying that now, in a sense, it is the democracy's non-democratic alternative to the representative government. अभी देखो, what is the meaning of this? I think it is self-explanatory, easy है समझने के लिए. It basically saying that in a democracy, क्या होना चाहिए? People should vote their representative, and hence the government is formed. But यहाँ पे क्या हो रहा है कि you don't vote for the appointment of the judges or the judiciary, right? So it is saying that democracy तो है, but democracy का एक non-democratical alternative है ये. Alternative किसके ऊपर है? Representative government. That means friend Becher basically criticizing that जब लोग, आप लोगों को, when the people voted the representative to be part of the democracy to take care of them, when they don't do the work, then definitely the judiciary will come up and they will be the alternative to do the work for the people. So this is said by friend Becher. Okay, बहुत interesting statement है. Now, according to Upendra Bakshi, says that if the executive or legislature defaults on its legal and constitutional obligation, courts cannot for longer take a view that violations of rights involved in such default. in such defaults are of no concern to them. So what Upendra Bakshi is saying? Upendra Bakshi basically says that कि अगर या फिर जब एग्जीक्यूटिव एंड लेजिस्लेचर दे फेल्ड देयर ड्यूटी, उनका जो कॉन्स्टिट्यूशनल ड्यूटी है, उनका जो लीगल ड्यूटी है, जब वो फेल कर देते हैं, तो इसमें से क्या समझ में आता है? दैट कोर्ट को ये समझ में आती है दैट दे विल नेवर बी एबल टू प्रोटेक्ट द राइट्स व्हिच आर ग्रांटेड टू द पीपल. अगर वो अपना ड्यूटी ही नहीं कर सकते तो लोगों का राइट्स कैसे प्रोटेक्ट करेंगे? ओके, एंड दिस इज द रीजन व्हाई जुडिशियल एक्टिविज्म टेक्स प्लेस. ये किनका मानना है? इट इज सेड बाय उपेंद्र बख्शी. ओके, मैं फिर से रिपीट करता हूँ. What Upendra Bakshi is saying? He is saying that judicial activism is required. कब चाहिए ये? When the executive and the legislature defaults on its legal actions. तो उनका जो ड्यूटी है on legal term और constitutional terms, when they fail to do that, इसका मतलब ये समझ में आती है that they are no longer be able to protect the rights of the people. Any rights, be it fundamental rights or normal constitutional rights or non-constitutional, any rights. So in that regard, who will protect that? It is only the judiciary. Okay, so we have understood this concepts of judicial judicial activism, or why the judiciary is over exercising the power. It's nothing but known as judicial activism. Okay, is this clear this much, all of you?
Yes, sir.
Yes, sir.
Okay. Now recently what has happened, you might see that there is an concept called as PIL, public interest litigation. Okay, so public interest, the name itself says that if there is certain I mean, if you look into the idea of PIL, it was actually means that if there is any big changes to be made and that is in the public interest, and if that is not directly done by the executive or legislature by law, so judiciary can take up that matter, and sometimes judiciary has the power to enforce or direct the government to do that. बट इट शुड बी इन पब्लिक इंटरेस्ट. ऐसा नहीं कि कोई पर्सनल चीजें लाके आप सुप्रीम कोर्ट के पास जाओ और बोलो कि सर ये मुझे चेंज चाहिए. दैट नॉट शुड नॉट बी पॉसिबल. इट शुड बी इन द पब्लिक इंटरेस्ट. So the idea of PIL, it was practically started in 1982 by the former Chief Justice. Okay, the former Chief Justice P.N. Bhagavati. P.N. Bhagavati. Okay. So basically means that the norms of the public interest litigations. There is a word, I don't know whether you know it or not. एक statement है basically which is popularly used in the practice of the PIL. Okay, so under the practice of the PIL, there is a norm which is used that is basically called as principle of locus standi. These are certain legal terms, but this question was actually once asked in the UPSC prelims exam कि locus standi का मतलब क्या होता है. Okay, the principle of locus standi, it means that, इसका मतलब क्या होता है? What do you mean by locus standi? It means that only aggrieved and affected persons and affected persons can approach the court in any matter. ठीक है, कोई चीज हो रहा है because due to which there are people who are affected. So the principle of locus standi, ध्यान रखना इसको, the principle of locus standi basically explains that the aggrieved and affected persons, they can approach the court directly. But जो PIL है, PIL is based on two principles. One is तो locus standi हो गया, दूसरा प्रिंसिपल ये भी है that the people who are not affected, that is the third party, who are not affected, they can also approach the court. ध्यान से सुनना, नॉर्मली क्या होता है, कोर्ट को कौन जाती है, who goes to the court? The people who are affected or aggrieved people, they go to the court. अगर कोई अच्छा इंसान हो थोड़ी ना जाएगा कोर्ट, है ना, तो जिनको प्रॉब्लम है वही जाएंगे. बट PIL में क्या है, PIL में दो चीजें हैं, एक तो इट ऑल्सो इंक्लूड्स द लोकस स्टैंडिंग, but at the same time it also gives an opportunity to the third party, those who are not even affected, they can also approach the court. That means आप ये बोल सकते हो कि it is more like an activism, it is more like an advocacy, कि मैं, आप प्रॉब्लम फेस कर रहे हो, मैं आपके लिए कुछ काम करूंगा. That is the advocacy or the activism. So PIL is giving the opportunity to the third party who is not affected can also approach the court. But if on what ground? Ground ये होना चाहिए, ऐसा ना कि कोई भी चीज उठ लेके आप कोर्ट के पास जाओ टू सीक द जस्टिस. द ग्राउंड ये होना चाहिए, on the ground that if wrong or actions involved of public interest, ठीक है, if wrong or actions involved in the public interest, then PIL फाइल किया जा सकता है. This is the very basis of the PIL. इसमें बहुत सारे डिटेल्स है and okay, there are many details. Probably the details are not so much of important as far as the PILs are concerned, right? So at least you need to have an idea. I'll just give you an example. एक टाइम पे क्या हुआ था, एक पिटिशन फाइल हुआ था. I'll just give you an example. There is a PIL फाइल हुआ था, जो NRI जो हैं उनको वोटिंग राइट मिलनी चाहिए. ओके, NRI को वोटिंग राइट मिलनी चाहिए. और एक भी PIL फाइल हुआ था दैट पार्लियामेंट में 33% रिजर्वेशन for women. So these PILs were dealt by Justice Kapadia. So he said that how can we direct the parliament? Okay, how can they direct the parliament to create certain voting and to create reservation for the women? These are the duties of the parliament to look into the matters, and when they feel fit, they can do that. So एक आप जुडिशियरी के पास आके आप बोल रहे हो कि आप पार्लियामेंट में 33% रिजर्वेशन दे दो. ओके, सो these are not entertained by the judiciary. आज भी देखो, there are multiple judgments sometimes happens. कभी कभी कुछ कुछ लोग ऐसे भी होते हैं कि they basically I'll just give you an example. All of you know Jui Chawla?
Yes, sir.
Yes, sir.
Okay, so
So she has fined like 15 lakhs.
yeah, she was basically fighting. She was activism for the 5G network. She was saying that 5G network are harmful for the for the country. There should not be any 5G network because of the wave and etc. Then the interestingly what happened, judiciary also was ready to discuss it. There is no issue. Okay, discuss karte hain. The petition was filed. Then it was during the COVID, and for that reason, what happened? It was on the Zoom. I mean, online basically. The session was going on online. So Juhi Chawla, she shared the ID and password in the social media handle. Right. So the judges were not happy. Judges said that they basically, the normal people, they disturbed the entire session. So judges were not happy. They basically said that you have done nothing but to gain popularity. अगर आपको PIL फाइल करना है, एक्टिविज्म करना है, then why to share everything on the social media? You could have said after the judgment also. क्या जजमेंट हुआ उसको लेके एक समरी भी आप शेयर करते थे, इंस्टेड ऑफ शेयरिंग द डायरेक्ट लिंक. अभी जैसे कि फॉर एग्जांपल वी आर डूइंग क्लासेस, अगर दिस लिंक इज शेयर्ड टू ऑल ऑफ द ग्रुप्स एंड डिफरेंट स्टूडेंट्स विल कम, they don't understand the tuning between us, so they might disturb the class also, you know? So she was fined and the PIL was also rejected. Multiple examples are there. So you can see this activism, this judicial activism itself, it was not in the beginning. अगर आप try to talk about the evolution of the judicial activism, आप पहला जो 30 साल, first 30 years since the independence, I don't think you will see any kind of activism. Okay. So now today in India, you can see there are two aspects of the judicial activism, जो कि already मैंने आपको बता दिया. एक तो है कि जो when the judiciary gives directions. दूसरी type of activism you will see when somebody files a PIL, and after that, based on the PIL, the judiciary takes certain statements. Okay. Now, we know that during the emergency provisions, I mean, approximately 2 years of emergency during 1975 by the Indira Gandhi, and which time when Keshwananda Bharati case that came up, Keshwananda Bharati case was very particular, and there was a statement in the Keshwananda Bharati case that the executive do not have any right to tamper to the constitution. Because the Indira Gandhi wanted to change the constitution so that she can get more power. So the judicial activism, I mean the Keshwananda Bharati case, the judgment also have a one statement that you cannot tamper with the constitution. आप constitution के साथ खिलवाड़ मत कर सकते. That is the reason why the basic structure came out. नहीं तो उसका जरूरत ही नहीं होता. See, restrictions कब होती है? When there is certain violations, then only the restrictions comes. Because the violations were done by the executive, I mean former parliamentarians as well as the executive. So Supreme Court came up with the idea of the basic structure. Right. So you can see the first major judicial activism. It was, I think, in the year of 1980. It was related to the Indian Express, the Agra protection, protective home. There is a writ petition under Article 21, and there was a big article in the Indian Express, editorial article. So based on which the first incident you can see the activism is 1980. But what I feel that the details of the story and etc. probably what are the types of, अभी जितना तक मैंने आपको बताया that all of these examples, the courts, the people, sufficient. There are also certain examples. I feel that I just say, for example, this um, Agra Protective Home, okay, a grid petition file हुआ था. Then there is an CBI related, I would say, activism हुआ था. There is also another activism in 1996 when the Supreme Court of India has made the chiefs of the central investigation agencies personally answerable to the investigations into the criminal and income tax FERA offenses. So ये example, these are examples are not so important कि कहाँ एक्टिविज्म हुआ, जजमेंट्स क्या क्या हुआ, कौन सा केस हुआ, कितना पैसा, कितना फाइल क्या हुआ है. जैसे 1996 सुप्रीम कोर्ट में 500 करोड़ से रिलेटेड एक एनिमल हस्बेंड्री स्कैम हुआ था बिहार में. Okay, and the Patna High Court was actually dealing with that, and then the court has directly directed to the CBI to do that duty. So there are various examples are there for your examination. जितना मैंने आपको पढ़ाया है that is sufficient because you cannot remember each and every example of small things. Judiciary बहुत एक लंबा subject है, इसको आप इतना डिटेल में भी नहीं लिख सकते हो. Okay, so what as a summarize, what we have understood is basically, if we look into the activism, okay, if we look into the activism, as far as the activism is concerned, we have understood that judiciary is overstepping for the benefit of the people. Okay, and क्या benefit है वो भी हमें पता चला that where the social and public interest, there is a change to be needed, and when the executive or legislature doesn't take any actions, there comes the judiciary. तो यहाँ तक this is the complete of the judicial activism.